On Tuesday, the President of the European Commission, Ursula von der Leyen, announced that the European Union is considering to move on very aggressively and start imposing ban on young people to use the internet and in particular social media sites. And because it is very immediate and because I knew that it will be also touched upon here in the conference, I thought I should perhaps concentrate on that from the perspective of law and human rights research. Because you see, always in these situations when there is talk about imposing certain restrictions and regulations and restricting the capability of young people to access internet, it has seemed to me that there is something missing. So today's short lecture's title will be The Missing Link, because I believe I discovered the missing link, and I would like to walk with you towards that road. Now, when Ursula von der Leyen was referring or was looking for an example, when she said that Europe will start to very quickly think how to limit the access of young people to internet, she was referring to the positive example of Australia. We all know that in Australia, the restrictive regulation was imposed about 1.5 years ago, but it's not a positive example. Actually in March 2026, there was published a study of what really has happened with that restrictive regulation. And the study found that about 75% of young people between 12 and 15 continued to use the same restricted platforms. Half of those people say it's very easy to circumvent the restricted accounts. And the conclusion is, it doesn't work. But what I would really like to talk about is there is an emerging narrative now when we speak about the need to restrict access of young people to the internet. I think nobody doubts, and especially the esteemed colleagues from the fields of psychology and psychiatry, we all feel that internet usage and abusive internet usage is damaging or at least very dangerous to the mental well-being of young people. But recently in Utah, in the state of Utah in the United States, which tried to impose the same restriction, the judge in Utah stopped that. Yes. The argument of the judge was that this restriction is violating the freedom of expression of young people. And I have seen it very often that in policy debates and discussions which influenced really the roots of the society, human rights argument enters sooner or later. And now the human rights argument has very clearly also entered this topic. Maybe you know, but I know already some names of scholars also from European human rights discourse who support the narrative or the idea that it's not justified to restrict the access of young people to internet sites and especially social media because of the human rights argument, because of the argument that they are then not able to express their views and they don't have access to information. What do we see here? We see here a human rights argument on the table. From human rights law and from human rights practice, we know that human right is something which should take priority over all other rights if there is a conflict. Human rights need to be given priority in any situation. So I was looking if into this argumentation could be entered a counter-force, a counter-argument, which is also on the level of a human right, so that we could say that now, when we speak about the justification of restricting the access of young people to internet and to social media, what is the counter-argument to say that it's okay to restrict their freedom of expression? It's justified to restrict access to information in social media sites, because it can only be justified when we have a right which is on the level of a fundamental right. In my search, I stopped for the first, at the beginning, I stopped at a claim which is not very widely known. It is titled "The Right to Mental Integrity," but very few of you have heard about it. It has been advanced by some scholars in Germany, and it is more an intellectual abstraction, yes, intellectual journey. The right to mental integrity is not yet codified in any international legal instrument. So I decided to look deeper. And you see, what is marvelous about conferences like this is that sometimes the reply to the question is just in front of you. And I would argue that the justification to limit the access of young people to social media and to internet, and to accept that it is justified to some extent, limit their freedom of expression and access to information, the counterforce is the freedom of thought. You see, the freedom of thought is something that we very rarely think about. Freedom of thought is nowadays, at least in European legal space and societies, considered to be one of the most fundamental human rights. But what is in the nature of any human right? In the nature of any human right is that if you have a right, you also need to have an obligation. For a very long time, it had seemed to me that the freedom of thought is an abstract entitlement, because how can government guarantee your freedom of thought? Freedom of thought is something which is internal. How can government come and say, yes, I allow you to think the way you want? Allow me a short excursion here. One of the first human rights documents in the world, 1789, the French Declaration of the Rights of Men and Citizens. If you look at the text, this text does not include freedom of thought. Around that time, the American Constitution was adopted, one of the oldest constitutions still in effect. It does not include the freedom of thought. It's not there. The freedom of thought entered the arena of fundamental rights after the Second World War. Yes, it has now been codified into the United Nations General Declaration. It's also in the EU Charter of Fundamental Rights, and also, of course, in the European Convention for the Protection of Human Rights. And you see, when I said a few minutes earlier that if you try to think of the nature of the freedom of thought, how can government guarantee you that right? But I think in the example or in the situation when we speak about internet and when we speak about the problematic usage of internet, it's actually the first example I know when we can see that there is a very clear interference and manipulation of the thoughts of young people. It's hidden, but it's very direct. We have seen a lot of evidence today. So my argument would be that when in the future people advance the claim that no, we cannot restrict the access of young people to internet sites and to social media because it would restrict their freedom of expression and access to information, as a human rights lawyer, I can propose a counter-argument and say it is justified because of the need to protect freedom of thought. It's the only justification I can think from the human rights perspective. And I'm not claiming authorship to this idea. Yes, it is quite possible that there are other scholars who have advanced the same argumentation. But if you want to take something with you, in addition to all the excellent presentations you have heard today, take something with you, take with you this idea that we can balance access of young people to internet because of the need to protect freedom of thought. So thank you very much.